What a strange beast the Child Support Agency is. When Parliament set the Child Support Agency up, it created a child support formula, a fairly strict mathematical way of determining how much child support is to be paid between separating couples. Into the formula goes the party's income, into the formula goes the ages of the children and how often one party sees them, and out of the formula is ejected an amount of child support to be paid between the parties. All fairly standard public service stuff. But then Parliament also gave the Child Support Agency the ability to vary the amount of child support to be paid pursuant to the formula. If the Child Support Agency was unhappy with the formulaic outcome, felt it didn't reflect properly the party's circumstances, the agency was given the power to change the amount to be paid. The agency calls that the change of assessment process. Not standard public service practice, more the hallmark, I would suggest, of a court. If you owe the Child Support Agency money, the Child Support Agency can go directly to your bank and order your bank take the money out of your account and pay it to the agency. If you are said by the Child Support Agency to owe it money, the Child Support Agency can issue a departure prohibition order to stop you leaving Australia. Again, these are not typically hallmarks of public service departments. They're hallmarks of courts. Now, I don't want this short video to become too complicated, but what we're talking about here is the separation of powers doctrine. The idea that public service departments make public service decisions, and they're made by public servants, and courts make decisions that courts make, but made by judges. It's a very important principle because judges are given security of tenure. They're appointed by the Governor General under the Constitution until they're 70 years of age, and citizens like you and me can have confidence that when a judge makes a decision, the judge is not beholden to the government. The judge is separate from the government. Judges, as I say, can't be sacked. They can't have their pay reduced. They're given constitutional tenure. And it's very important for citizens like us to be able to have confidence that judges are in that position. And of course, public servants at the Child Support Agency are not in that position. That doctrine applies in Australia, Canada, United States, England. All common law countries have this process of court-type decisions being made by tenured judges and not public servants. It's fundamentally important. Now, that all raises the issue of whether the child support scheme is constitutionally valid, because it seems to be making decisions that are normally made by courts, but the decisions are not made by judges. There are no judges who make decisions at the Child Support Agency. And the issue came before the High Court of Australia in 2002 in a case called Luton and Lessels, which is reported at volume 210 of the Commonwealth Law Reports. Those of you with a law library will see that the case is cited at page 333 of the Commonwealth Law Reports for that year, volume 210. If you don't have access to a law library, you can look at the case on the Austlii website. Now, when you read Luton and Lessels, you'll see the High Court was challenged here. On the one hand, clearly the Child Support Agency was making court-like decisions. But on the other hand, the High Court didn't really want to cause all the chaos of striking down the child support scheme. It would have created all sorts of issues. So in the end, the High Court upheld the child support scheme. It said the scheme was constitutionally valid, largely because the High Court said that ultimately any decision the Child Support Agency makes can be reviewed in a court. So ultimately courts can have oversight over the Child Support Agency and its decision making. Now, some of us at the time thought there's pretty marginal reason to uphold the scheme, but of course when the High Court says something, you just accept it. And that situation continued until about 2007. In 2007, the Parliament changed the law, so no longer could the child support agency decisions that affected periods of time more than 7 years back be subject to court review, which meant that again this issue was up for grabs. Was the child support scheme actually constitutionally valid? But it's something that very few citizens can ever do anything about, because mounting a constitutional challenge is expensive. You'd need the wealth of a Clive Palmer or a Gina Reinhardt or a Jamie Packer to be able to mount that sort of challenge. Well, Clive, Jamie and Gina, I know you enjoy your litigation. If you're having child support problems and you want to make a full frontal attack on the child support scheme, contact me. We could have a lot of fun over this issue. I'm Simon Bacon. I was a child support lawyer for 35 years, and if you want to know more about this subject, have a look at my website, childsupportlawyers.com.au.